What happens if a person admits that they will not be able to pay in terms of the CPA notice? So let me just frame the question slightly differently for the benefit of our viewers. So in terms of section 14 of the CPA, obviously, you need to give a tenant 20 business days to remedy his breach before you can cancel the agreement, but only if he doesn't remedy the breach. And so you do the letter of demand, give him 20 business days. He replies and says, peace out, I'm not going to pay. Does that affect the timelines? Can you cancel earlier? What's the story there?
Oh, look, it's an interesting one from the perspective where I do understand where the people are coming from, though. If you're sending out a notice saying you have 20 days and the person responds and indicates that they have no intention at all within paying and they're quite express about it, I do get why a person would feel, well, why do I need to wait out the 20 days? All right. And at a stage, we even looked around case law to distinguish between legislation that requires a notice to have a certain period of time versus the need to actually just have a certain period of time, right? Irrespective. Now, the reality here is, number one, you're dealing with Consumer Protection Act, which has always been very pro-consumer. And if there's any confusion as to where the advantage needs to lie, the consumer will inevitably get the advantage. So giving 20 business days notice as the Act requires gives me the impression that, yes, the notice needs to have the 20 business days, but they also need to be afforded 20 business days irrespective of whether they pay or not. So even though they expressly say that they have no intention of paying, erring on the side of caution, certainly, and also kind of leaning towards leaning 80%, 90% towards a full legal opinion that you're going to need to wait out the full 20 days because the Act requires it. I would say, sorry, you cannot get out of that contract earlier. You're going to need to wait out the full period of time. What is interesting, and people often don't realize this, is remember that 20 business days is simply for the cancellation of the contract, which is, yes, the eviction in terms pursuant to a cancellation. Doesn't necessarily deal with your right to collect. So nothing requires you to wait 20 business days before going out and collecting, depending on what the contract says, of course. So that's just a little something to throw in there. If you're waiting out the 20 days, you could actually also start looking at other processes if you are desperate to get the ball rolling.
I agree 100%.